Good afternoon. This is Tammy Weber, and welcome to Marshall Parker and Weber's webinar on partners versus spouses, the pros and the cons. As with everything, estate planning is case and fact specific. So if you have questions throughout, you can either send them, or if they're very specific, we recommend that you set up a consultation with one of our certified elder law attorneys. This webinar will apply to either opposite or same-sex partners or spouses. When we look at estate planning, there are different facets: wills, powers of attorney, the probate process, trusts, healthcare directives, and the like. So we're going to address each one of those. So first, a healthcare power of attorney, we recommend both a healthcare power of attorney and a financial power of attorney for an individual age 18 or over. And that document is where you name a person or a person, sometimes known as your agents, to make the healthcare decisions for you when you're unable to do so. Some people call this a living will. Some people call it an end of life. Some people call it a POLST form, POLST, standing for Physician Order Life Support Treatment. So those things talk about end of life decisions, but a health care power of attorney will always also address HIPAA or really just treatment decisions. And you might want to put in it, what is your philosophy on end of life? If a physician or physicians has said that you have an end-stage medical condition, do you just want comfort care, or do you want to be placed on machines to artificially prolong the process of your dying? If you haven't done a document and you haven't named a person or a person, Pennsylvania enacted Act 169 in January of 2007, and that act gives priority in descending order to your spouse and adult children that are not the children of the spouse, then your adult children, your parents, your adult siblings, your adult grandchildren, and your adult close friends, people that would understand what you would want. So in this situation, if there's more than one person in that class of priority that I just reviewed, the majority rules. If they can't decide, and then no decision is deemed to have been made under the law, and nothing's going to happen so that disagreement is resolved. And this could result in an important and significant delay in your treatment. Healthcare services don't usually recognize family or choice in medical decisions. They want to look at the document you have, or if you do not have one, they will rely upon the law and what it says. So in this order of decision makers that we just reviewed, a non-married partner may have no decision-making abilities regarding their partner's health care or end-of-life wishes because they're listed at the end. So if it's not on paper, others may make decisions for you, and they may not be the people you would choose to make the decisions, and they may not be the decisions that you want. So with everything in comprehensive estate planning, you also might want to let your families know what your choices are and have the discussion. So the con of not having a document if you are in a committed relationship but not married is that somebody else will be making your decisions instead of your significant other. The financial power of attorney is also an estate planning document that you should have starting at age 18, and that is where you name a person or persons to handle your finances. Things like paying your bills, paying your taxes, filing for things for benefits with the state, etc. And for some people, that includes doing asset protection in order to have more options for you if you were to get incapacitated in your lifetime and wish to need or have to have nursing home care or nursing home care at your home. There isn't a law like the Act 169 for healthcare with respect to the financial power of attorney. You just can't say, oh, I'm married, or here's my spouse, my partner, so they can handle things for me. No. If something were to happen to you and you were to be incapacitated in some way that you couldn't handle your finances, then the only other option currently under Pennsylvania law, if you didn't have a document, would be a guardianship. A proceeding would have to be started in the local courts in the county in which you lived, and a judge would make a decision. If they're a guardianship, the people that received notice of that petition are the same people that we're going to review that would inherit if you died without a will. And those don't include your significant other or partner. The other point here is if there's a crisis, something has to be done quickly in a financial mode. There could be damage or loss of money by a delay in having to file for a guardianship proceeding. So very important to have, whether you're married or if you're in a committed partner arrangement. So the other estate planning document that most people are familiar with is your last will and testament. And again, that's a written document that lays out who is going to inherit your estate. So things that are in your name alone when you die go under your will. Often people call this as the probate process, taking the original will with the executor or executors, whoever you've chosen to name, to the courthouse where you passed on and start the process of being able to get your assets where your will states. If you pass without your will, a lot of people, one of the things that we hear often is, oh, the state gets your money. No, not quite. Your property is distributed according to Pennsylvania's intestate succession law to the closest surviving relatives. So there would be a list. That list is your spouse. If no spouse, then your children, your parents, your brothers and sisters, your nieces and nephews, your grandparents, your aunts and uncles, etc., with the last being the Commonwealth of Pennsylvania. So you didn't miss it. Partners are not included in that list. The other thing to keep in mind is if you do not have a will, Pennsylvania also says where the money goes. So if you did have a spouse, that spouse would receive the first $30,000 and half of the remaining. And children, if you had any, would receive the other half. So again, that may not be who you want to receive your money that you worked hard for during your lifetime. Additionally, if you don't have a will and you haven't named the executor or the executors to handle things for you, the name of the person that would handle the distribution of your assets according to the Pennsylvania intestate succession law would be an administrator. And so that administrator, the person that is chosen, is the same list as I went over of the people that would receive your assets. So again, it would not be your partner or your significant other that would administer your estate if you do not have a will. Another option in estate planning are trusts. And as with many things in this webinar today, we could talk a lot about trusts. I'm going to hit the high points for you. Trusts are a lifetime planning option, and they're in writing. And there are really two main kinds, a revocable living trust and an irrevocable trust. When we're dealing with unmarried partners, often, although everybody's circumstances are different, we would use a revocable living trust, meaning each partner would have his or her own revocable living trust and choose whatever assets they would want to retitle from their individual name into the name of the trust. So each partner would remain the trustee of their trust, meaning they could always change things during their lifetime. But upon death, that trust would become irrevocable. And in that trust, you would list your partner as the beneficiary of your assets. These work rather well, and it's one way an estate planning technique. There's also an irrevocable trust. Now, if one of your other additional plans is asset protection in case there's a nursing home stay in the future, may be an option, but you can't be the trustee of your own trust, and the ability to change it during your lifetime is limited. Another thing that we see with our clients is often overlooked, not updated, or they're really not clear, are our beneficiary designations. So there are accounts like life insurance or an annuity or retirement accounts like 403Bs, IRAs, 401Ks that you list a beneficiary. It's a contract. So if you were to pass away, that contract determines who gets that asset. It doesn't go under your will. If you choose to put as your beneficiary designation your estate, then the proceeds would pass through your will. But there are some tax reasons not to list your estate if it's a retirement account, for example, and if you deferred the income for a period of time. So it's really important to not only name a primary beneficiary, so you could name your partner or you could name your spouse, but also name a contingent beneficiary. Because most people, either if they're married or they have a partner, do travel together, they do things. So there would be a possibility of both passing on at the same time. So a contingent beneficiary is very important. You can get those by calling your life insurance company or your annuity company and just asking, send me a letter. What do I have? Who are the current beneficiaries? And get those change of beneficiary forms if you need to add a contingent beneficiary. There are also long-term care considerations. So again, if you, your spouse, or your partner may need long-term care in a nursing facility, or that level of care in your home and apply for medical assistance, which some people call Medicaid here in Pennsylvania, it's based upon your assets and your income. And when you are married, there are certain specific exceptions, mainly retirement accounts, but the combined assets, regardless of whose name they're in, are considered available to pay for care. And I guess the positive or the pro to being married would be that you can share the assets, and there are some impoverishment rules, to protect your spouse. So in other words, if the total pot of money with both spouses is $200,000, the spouse that doesn't need the care can keep half of that amount and up to a maximum currently of $128,640. Or if the pot is much smaller, say it is $40,000, the spouse not needing the care can keep the minimum, which is currently $25,728. It's called the protected share. If you weren't married, the person needing the care would just be treated as a single individual, and the plus is their partner's assets wouldn't have to be spent in order for them to get on Medicaid. The negative is they'd have to spend their assets down to $8,000 or less in order to get on Medicaid. So that's one protection. There's also an income protection. So if you are married, for example, and your spouse went to the nursing home, the spouse's income is considered available and is a contribution towards their care, along with the Medicaid payment. If the spouse at home has very low income, maybe $800 or $900 of Social Security, and that's it, if you're married and under Medicaid, the spouse in the nursing home, some of their income can be diverted or given to the spouse that's at home. And currently, the spouse at home is entitled to have at least $2,114 a month. If you were partners, there wouldn't be any diversion of income from one partner to another. So that would be a con. The other thing that we look at when we're talking about planning and requesting Medicaid or medical assistance, when you do so, when you file, you might have heard of the 5-year look back. And that look back says if you're married, either spouse has given anything away more than $500 total in a calendar month, that a period of ineligibility would flow from that. But the laws do allow things to be transferred from one spouse to another without any penalty. If you were in a partner situation and you had too much money to qualify for Medicaid, you couldn't just transfer it to your partner, to your partner without invoking the 5-year look back. In other words, it would create a period of ineligibility, just as if you had given money to a friend, to a child, or to a relative. Now we're going to switch gears a little bit to tax planning. Nobody likes taxes, but it's good to know about them. So let's talk about federal estate and gift tax. Now, this kind of gifting is different than what we just talked about for Medicaid. So if you're applying for Medicaid, anything more than $500 total in a calendar month creates a period of ineligibility. This is federal estate tax. So I was doing some research the other day and read an article that of the people that are projected to pass away in 2020, about 2.8 million, only less than 0.1% are going to file a federal estate tax return, which is a Form 706. And so it looks like about 4,100 they anticipate will be filed, but only 1,900 would have to pay any of the federal estate tax at a rate of 40%. And you can understand why those numbers happen, because if there's a gift tax exemption of $11.58 million, that's the wealthiest echelon that we have here. When you're married, you can double the amount that you can transfer to beneficiaries without federal estate or gift tax implications. By that I mean, so if it were a married couple and they wanted to give their child $30,000, they could each give $15,000 per year without having it affect their lifetime $11.58 million exclusion. Now this number changes every year. It's scheduled to sunset in 2025. We don't know what's going to happen, but again, this is what it is currently. The other pro of being married for this purpose is if you're married and your spouse dies, and say, for an example, he has $5 million when he passes on. He's not subject to the federal estate tax, but he's left a $6.58 million unused exemption from federal estate tax. So if you're married, the remaining spouse can file a return and apply to have that additional $6.58 million apply to his or her lifetime gift. It's called portability. And as long as the surviving spouse doesn't remarry, it's a positive. That option is not available with a partner. Pennsylvania inheritance tax is more familiar and what most people have to pay because in Pennsylvania, when you pass away, tax starts at $1 and it is based upon the relationship of the person who died to the beneficiary. So currently the rates are 0% to a spouse, 4.5% to the lineal heirs like children, grandchildren, parents. This also includes stepchildren at 4.5%. Brothers and sisters or siblings are 12%. Others are 15%. And charities and other exempt entities are at a 0% rate. Partners then would fall under the 15% tax rate. The only exception to Pennsylvania inheritance tax at 0% rate for whomever receives it is life insurance. And I will say there are some limited exceptions to tax depending upon what is passed from the decedent to the beneficiary. Another type of consideration, whether you should marry or not, or you have a spouse or a partner, is health insurance. So if you have a couple that are married, one doesn't work outside of the home or works at a location that does not provide health insurance, you would want to have the employer health insurance coverage plan to allow that person to be covered. We're seeing a trend that there are more and more health insurance plans allowing a non-married partner to receive health insurance, but it's not a given. So that could be a significant con or a financial amount of money that would have to be paid if your partner and you are not married. Another consideration is Social Security. So Social Security recognizes marriages. There's a one-time spousal death benefit. When one spouse dies, the lower earner spouse has their Social Security typically bumped up, but generally unmarried couples do not benefit. Before there was marriage for same-sex couples, the Social Security Administration would issue various opinions, and it was very complicated as to who or who not was recognized. But you just want to keep this in mind. There's also the possibility of the Family and Medical Leave Act. Most people know that as FMLA. Now, this act doesn't apply to all employers. For example, there has to be more than 50 employees and some other requirements. But if your employer is covered, it allows an eligible employee to receive 12 weeks of leave for certain medical reasons during a period of 12 months. In Pennsylvania, under FMLA, a family member is defined as a spouse, whether they're same sex or opposite sex, a child, or a parent. So for example, if you were an unmarried couple and your partner had some health issues and needed to stay home and you wanted to stay home with him or her in order to help them, you would not be covered under the definition of family member because you are not a spouse. On the flip side, if you and your partner had children and a child had an issue and you were applying under FMLA, a child would be covered. The other thing is thinking about creating a funeral plan. Funeral arrangements, now most people don't like to think about this, or some people are, just afraid, they're superstitious. But if you haven't set up funeral arrangements, the order of decision makers under Pennsylvania law is spouse and then next of kin. And the definition of spouse currently does not include a partner. And if persons with equal standing as the next of kin disagree, then the court determines what's going to happen, and the preference is given to the person that had the closest relationship with the decedent. This can be a little bit tricky. There is a little conflicting law, so a different statute that covers the healthcare power of attorney says or implies that the healthcare agent's authority could extend beyond the principal staff to make anatomical gifts, get rid of remains, and consent to autopsies. So just something there to be aware of. So the answer to all of this is to pre-plan your final arrangements. So meet with the funeral director of your choice, tell him or her that you want to be, traditional funeral, buried, cremated, whatever service you want, ashes to be spread. Now, of course, there are laws that cover what and where, if at all, ashes can be spread. But have that in writing, prepay it, get just a very good itemized, this is how it's going to go, especially if you're in a partner situation. And then also outline it in your estate planning documents. So if you're doing your last will and testament, you could, for example, say, I wish to be cremated. My executor will have the sole decision-making authority as to when and where. And some people even start arguing about the choice of urn or where the ashes go, who gets them. So put that in your estate planning documents. I like to do it both in the will and also in the healthcare power of attorney, just in case. And this is a great way to avoid any conflict, and is very helpful if the partner, if family members may have other opinions. You don't want to have to deal with this when somebody passes on. You don't want to leave that as your legacy. I don't see any questions from anyone. So I will tell you that we're recording this and we will be saving it to our YouTube channel at paelderlaw.com. Thank you very much for joining us. Have a good day.